Well, good morning, everyone. As you can probably tell, I'm not Chair Rosenbaum. He is out today, and I've been asked in his stead to help move us along. So this is the start of the Organic Control Commission meeting for today is Thursday, March 24th, 2019. And Laura, could you call the roll?
Commissioner Curran.
Here.
Commissioner Floyd.
Here.
Commissioner Harper.
Here.
Commissioner Melinas.
Here.
Acting Chair Reval.
Here. Great. And I'm keeping this away from Harper, so put this over
I've got
here.
it.
So we're going to start today with contested hearings. Michael?
Good morning, Chair Reval, Commissioners. I'm Michael Shine from AP&P. Joining me is Paul Loney, attorney for Earth People's Garden LLC and its managing and sole member, Stephen Shirley. This is a proposed denial of Earth People Garden's application for a recreational marijuana producer license based on false representations to the Commission. Before you for approval is Senior Administrative Law Judge Dove Gutman's proposed order in which she recommends denial of this license application. I'm going to present the Commission's case, then turn things over to Mr. Loney to argue his client's exceptions to the proposed order, after which I will ask for a chance to respond to Mr. Loney very briefly before you retire to deliberate. We will confine our remarks to the evidence of record and to the exceptions and comments that were filed, and we'll try to limit our remarks to about 10 to 15 minutes each. Earth People's Garden LLC's grow site is located in Cave City, Oregon, about 65 miles west of Medford. Earth People's Garden's application for a producer license was assigned to OLCC license investigator Amy Naveen. After reviewing initial submissions and speaking with Mr. Shirley, the sole member of this LLC, investigator Naveen determined that Mr. Shirley would be a hands-on grower. So there are two rules that come into play here. One requires that, and this is a quote from 7502, a licensee must have at least one license holder who is a CTS administrator, for which purpose you need to take a metric training and show that you've passed the metric test. CTS is the Cannabis Tracking System. It's administered by a company called Metric, so metric and CTS means about the same thing. Since Mr. Shirley was the sole member of Earth People's Garden, that meant in this case that he had to pass the metric test. The other rule that comes into play here requires that anyone who handles or produces marijuana or who enters those transactions into metric or supervises persons doing these things must have a marijuana worker permit. To get one, you need to pass a worker permit test. Since Mr. Shirley told Ms. Naveen he would be a hands-on grower, he needed to pass a worker permit test. So Ms. Naveen prepared a checklist of things that Mr. Shirley needed to submit to get his license. Among the things included were 1, metric certification test, and 2, worker permit test. Judge Gutman agreed in her proposed order that both a metric test and a worker permit test were properly made conditions of licensing under the circumstances here. On February 8, 2018, Ms. Naveen received, on behalf of the Commission, a packet of documents for the Earth People Garden application, which included a certificate stating that Mr. Shirley had passed his metric test and another certificate stating he had passed his worker permit test, both tests on February 7, 2018. The problem is that Mr. Shirley spells his last name this way, and the certificates spelled his last name this way. So they were misspelled. The last name was spelled S-U-R-E-L-Y, but the accurate spelling of his last name is S-H-I-R-L-E-Y. So The certificates were submitted by a consultant named Jeffrey Nichols of Green Springs Consulting, a company located in Talent, Oregon, which is right next to Medford. Along with the certificates, Mr. Nichols submitted an authorization form signed by Mr. Shirley, which authorized Mr. Nichols to act on Mr. Shirley's behalf regarding Earth People's Gardens application. Investigator Naveen thought something might not be right, so on February 14, 2018, she called Mr. Shirley. In response to Ms. Naveen's questions, Mr. Shirley truthfully admitted that he had not taken the test, that in fact Mr. Nichols was the one who had taken the metric and the worker permit tests. Ms. Naveen told Mr. Shirley that these tests were not valid because Mr. Nichols took them instead of Mr. Shirley, but she gave Mr. Shirley another chance. She instructed Mr. Shirley that he had to personally take the test. She confirmed this by email and copied Mr. Nichols with that email on the very same day, February 14. Mr. Shirley testified that he told, after speaking with Investigator Naveen on February 14, he clearly understood that he had to personally take the metric and worker permit tests for the results to be valid, and he told Mr. Nichols that. On February 20, 2018, Mr. Nichols submitted a second set of test certificates to the Commission via email to Ms. Naveen. These certificates were in the name of Stephen Shirley spelled correctly, attesting to his satisfactory completion of the metric and worker permit tests. Unfortunately, they proved to be false. Investigator Naveen contacted OLCC worker permit specialist Emily Johnson, who reviewed computer records and reported back that the worker permit test had only been taken one time on February 7, so it had not been retaken. The email address on the worker permit test account was greenspringsconsulting@gmail.com, which is Mr. Nichols' email. And the only other logins to this account after February 7 were made not to retake the test, but to correct the spelling of the name on the certificates. Investigator Naveen contacted Tricia Mills, metric support desk supervisor, and requested a review of Mr. Shirley's metric test records. Ms. Mills reported back the following information, to which she also testified at the hearing, and incidentally, Emily Johnson also testified at the hearing. So Ms. Mills reported that Jeffrey Nichols had taken and passed a metric test back in 2016 for another applicant. He saved a link to the 2016 test. On February 7, Mr. Nichols accessed the old link and took the test, the 2016 version, for Mr. Shirley. He did the same thing again on February 15, 2018. She testified that Mr. Shirley did not sign up for or take 2018 metric training. And she testified that both 2018 test certificates were generated from an account with an email address, greenspringsconsulting@gmail.com, and an IP address of 96.41.138.206, which is pretty precise, but it becomes important as we go along. So on February 8, 2018, Investigator Naveen contacted Mr. Shirley by phone to discuss the second set of test certificates received February 20. In response to Ms. Naveen's questions, Mr. Shirley stated that he did take the test, that he took it with his consultant, Mr. Nichols. He took both tests at his grow site in Cave City on his computer. Mr. Shirley later testified at the hearing that after speaking with Ms. Naveen about the first set of invalid test certificates, and after telling Mr. Nichols he had to take the test personally, Mr. Nichols came back to him and said, "Don't worry, I've already resubmitted those tests for you." And he said Nichols told him that Shirley had to back him up on this or he would not get his license. So rather than tell the truth, Mr. Shirley did back Mr. Nichols up by telling lies to Ms. Naveen on March 8. At the hearing on direct examination, Mr. Shirley testified he regretted what he had told Ms. Naveen on March 8. In cross-examination, he explained why. And the question was, why is it regrettable that you told somebody you took the test yourself in Cave City? Mr. Shirley, because that I shouldn't have. Even though I thought maybe he, Nichols, could take the test, I shouldn't say that I took it. Mr. Shine, so you knew that was false, right? Mr. Shirley, I knew. Investigator Naveen checked the IP address of the computer on which the metric test had been taken. That IP address traced to Talent, Oregon, which is where Mr. Nichols' business is located, and not where the grow site is. According to Google Maps, Talent, Oregon is 66.9 miles from Cave Junction, where the grow site is located. A computer forensic analysis by OLCC Network Administrator Mark Otterbein presented at the hearing concluded that this IP address traces to the Medford Talent area, and that more likely than not a computer used in Cave Junction could not produce that IP address. On May 24, 2018, Commission staff issued Mr. Shirley and Earth People's Garden LLC a notice of proposed license denial. The notice stated, among other things, that the following misrepresentations. One, on February 20, by submitting a false metric certificate and a false worker permit certificate, and on March 8, by falsely stating that Mr. Shirley took the test and that he did so at his computer in Cave Junction. So by statute and rule, the Commission is authorized to deny marijuana license applications if the Commission finds that the applicant has made false statements to the Commission. Under Commission precedent, there's 3 elements to a false statement denial. First, that there was false statements or misleading information submitted. Second, the false statement was material. And third, this denial ground can be overcome if the applicant shows good cause. I will very briefly discuss how these apply. I think the false statement or false statements are self-evident. They are the ones that were charged, that I read you from the notice, on February 20, submitting falsified test certificates, and on March 8, stating that he took the test and he took it at his grow site. It has been argued that there was only one false statement, and that was where he took the test. It is the Commission staff's view, and this was upheld by the ALJ in her proposed order, that in fact there were multiple misrepresentations at each test certificate submitted on February 20, and that the statements made March 8th were all misrepresentations. Also, it's been argued by counsel for Mr. Shirley that Mr. Shirley is only responsible for his own statements March 8 and not what Mr. Nichols did. He relies on Vaughn versus First Transit, which is an Oregon Supreme Court case. I would note the Vaughn case analyzed agency under the Oregon Tort Claims Act for civil negligence liability, and so it is not applicable in this administrative context at all. Judge Gutman rejected Mr. Shirley's argument in her proposed order, citing Commission precedent that holds that licensees and applicants are responsible for the actions of their agents and representatives, even when those representatives are independent contractors. Furthermore, Judge Gutman found, based on the contract between Mr. Shirley and Mr. Nichols that was in evidence, plus Mr. Shirley's testimony, that Mr. Nichols was specifically authorized to complete and submit tests to the Commission on his behalf, which took the case factually out of the Vaughn precedent. On the question of whether the false statements were material, there are 3 elements under this Commission's case law for materiality. First, is it relevant to a denial criterion? Second, does it inhibit the Commission's investigation? Or third, is it intentional? Commission staff argued that all 3 apply. Judge Gutman found the first applied and therefore didn't have to reach the other 2. But based on Mr. Shirley's testimony that what he said was false and he knew it was false, we think that intentional is pretty clearly shown here as well. But it's also relevant to denial criterion in that we would have denied the license if Mr. Shirley was unable to show that he had passed either a metric test or a worker permit test, because under the circumstances they were made requirements for this license, and that's what the judge found in the proposed order. Finally, on good cause, I won't address all the elements. They're well analyzed in the opinions, but I do want to address the prior warning element. With respect to prior warnings, Mr. Shirley has argued that although he was warned that he had to personally take the tests, that was that discussion on February 14th, he wasn't warned about the need to be truthful. Long ago in Yasina Bakery and Meat Market, which is an OLCC decision from March 1998, the Commission answered a similar argument by stating, quote, applicants and licensees are expected to provide truthful and complete answers to OLCC questions. As Judge Gutman put it in her proposed order, truth-telling is a basic expectation of every applicant. Not only does this factor weigh against good cause, but the arguments offered on this point by Mr. Shirley demonstrate why Earth People's Garden and Mr. Shirley would not make a good partner for the Commission to license for working together in the marijuana industry. So I have nothing further at this time unless there are questions from the Commission.
Questions? Chair. Commissioner Harper.
My concern is twofold, Mr. Shine, in regards to this case. Can you give me the time lapse of how we ended up here in March of 2019? So we started, this application was filed in what year and what date? And did they have a prior license to this?
They did not have a prior license. They apparently have a medical grow. And the license application process was begun in March of 2016.
And they paid, and they did put their fee down to start the process. And give me that date, March of 2016, right?
2016, that's correct.
And then sort of explain to me how, after the 3-year process, we're here today.
Well, the actual active time, if you will, when the checklist of information, after reviewing it, the application was in queue for a time, and then in, let me get the exact dates here for you. It was in March, I believe, of 2018 that the checklist was sent. Oh, excuse me. No, August 2017 by email. So it wasn't really that long. August 2017 that a checklist of missing documents that were needed was sent by the license investigator to the applicant. And it was a long time before the applicant responded. It wasn't until, as I've said, in 2018 that they submitted the documents that were requested. For example, there wasn't a LUX, which is a land use compatibility survey that was needed, or statement from the local authority, and that's required. And so a good part of that time between the time periods that I was just speaking about in February 2018 and that August 2017 was the applicant himself kind of getting things ready, working with the municipality, preparing the documents.
And so, from my understanding, he had product on site.
Well, that was
medical.
it was an appropriate grow site under, as far as we know. I mean, we don't investigate the OHA licensed grow sites, but it was a medical grow site.
Okay.
And so whether he actually had product on site or not is not in the record here. I can't tell you.
Okay. And then,
but then after February 2018, the time periods that passed were, again, in March of 2018, a hearing notice goes out. They have 60 days in which to respond and request a hearing when there's a license denial that goes out. They did request their hearing, and then it took some time to schedule the hearing because of the ALJ's time period. And the hearing was...
I see here we denied the license April 24th of 2018.
Right.
And then that's where that 60 days started?
Oh, excuse me, the notice of proposed denial went out May 24, 2018. And then the hearing wasn't held until last summer. And then there was a period of some months before the administrative law judge, then Office of Administrative Hearings has it. They issued their decision. They issued a written order here. And so after that, there's a time period in which exceptions can be filed, and exceptions were filed, and then it took another couple months to get it on this commission's agenda.
Okay. So, and Chair, my final question is, in regards to, do we normally spend this much time on one license denial? There's a lot of man-hours on this thing here.
Well, this was our argument for another ground of materiality, that it inhibits the investigation when a false representation is made to the commission. The short answer is no. On most applications, they go through more efficiently because there is no false representation made. But when a false representation is made or falsified documents are presented, it becomes a much more complex sort of thing. And, you know, ultimately at the hearing, this applicant admitted that what he stated was false and that he knew it was false. But, you know, not everybody does that. And part of the reason they did that, I think, is because we had so much information already kind of sussed out. So, no, we don't ordinarily, but if a case is going to go to hearing and the applicant has an attorney on the other side, we put the resources necessary to be well prepared at the hearing. The administrative law judges expect us to be prepared, and I'm sure the commission would expect us to be well prepared when we go there.
All right, and the last question, Chair. You said that you determined that Mr. Shirley did not take the test for his his permit, correct?
That's correct.
And this is a more broader question, because we went and reviewed the IP address of this candidate, and that was just in preparation for this court case, correct?
That's correct.
All right, and you don't do that for everybody, right?
That's correct.
And then the second question is in regards to, in this file, you mentioned some of his academic prowess, saying that has some issues. Chair, I don't like that. In regards to identifying some of his medical history, it's nice for us as a commission to do our report and have it completed, but certain people graduate from college and certain people don't. Alrighty, so I would assume that these issues here in this file is not a reason why we should deny this applicant his license. Is that correct?
Well, that's absolutely correct, but Chair Raval and members of the commission, I want to be clear that the issue of this applicant's medical condition was not even part of the report on denial. That was raised as a defense, if you will, or an issue that was raised defensively.
By the opposing attorney? Or
yes,
not by us?
Right. And so then the question became whether that condition caused him to make these statements. So I asked him about that at the hearing because he had raised that issue himself. And he said no, that medical condition would not have caused him to submit a test with a completely different spelling of his name. It would not cause him to lie about whether he'd taken a test or where he'd taken it, because those were issues that were injected into the hearing.
Thank you, Chair.
Other questions?
Chair,
Commissioner Kern.
is there a method or a process by which if somebody does have a medical condition that would prevent them or make it difficult for them or have a disability, I would say, in taking those tests or something to that point that they could list that or get help with taking the tests in a different way? Is there where they could preliminarily, before this would have occurred, have let the commission know that they needed assistance?
Well, Commissioner Curran, I'm not sure whether there's a formalized process for that. That's a question for licensing. But I do know that our license investigators, as in this case, spend quite a bit of time with back and forth dialogue with the applicants. And in this case, you know, she went to him the first time around and said, look, these don't look right. And he admitted truthfully that he hadn't taken the test. And at that time, you know, there was dialogue. And if he were to raise that issue, you know, we don't actually, the commission doesn't administer the test. One is administered by Metric, the other is a test that's just online, you know, that you take. But if there was some claim that extra time was needed, I think that's an issue for licensing to respond to, but it may be that they would provide a reasonable accommodation of extra time or something like that for taking the test. Actually, I don't even think the tests are timed at all, is one of the things, but if there was some other accommodation needed.
Thank you.
So now I would turn it over to Mr. Loney to present his client's perspective.
Good morning.
Good morning, Chair. Good morning, Commissioners. My name is Paul Loney, L-O-N-E-Y, bar number 921854. I represent Earth People's Gardens and Stephen Shirley. And just kind of Commissioner's Curran last question is where I was going to start off, basically. But first, Mr. Shirley is a longtime resident of rural Southern Oregon. Have you heard outside of Cave Junction, down there in southwest Oregon, kind of forgotten area. But Mr. Shirley has dyslexia. I mean, he wanted to participate in the legal marketplace for cannabis. He was excited about it. He put his application in back in 2016. He started to go through all the paperwork, and then he realized he was having issues because of dyslexia. So he hired a consultant, somebody who was actually an OLCC registered producer, licensed producer by the commission here. And so he thought he was in good hands. That person helped him out. He thought we could help him out. You know, the consultant promised to help him with the paperwork. And like I said, he's a licensed producer. And then he thought everything was going okay until he hears from Ms. Naveen that there was an issue with the tests that were submitted on his behalf. He had no idea tests were submitted on his behalf. When Ms. Naveen asked him about it, he said, yeah, you know, he didn't lie then, February 8th. And even the administrative law judge pushed back against the commission staff and said, no, that was not a lie by the applicant. He truthfully said, I didn't take those tests. And Ms. Naveen told him, you have to take them. And he said, okay. He went back to his consultant and said, I have to take these tests. The consultant said, oh, too late. I already resubmitted them for you, and you're going to get in big trouble if you don't back me up on this. The consultant here was worried about his license, I'm sure, at that point. And from that point, that's kind of the history.
One moment, please.
Yes.
Commissioner Harper.
You just said that Mr. Shirley, the consultant that's a licensed registered producer, told him to back me up and you just be quiet and don't admit the truth, right?
Correct.
Okay.
That's what he said. That's what the consultant said. And because of his difficulty with filling out the forms earlier, he was worried because the clock was ticking. He was hearing that there was lots of applications in there, and he worried about not getting his license because he wanted to participate and do it legally. He said, okay, I will, you know, he just kind of acquiesced at that point. And then again, that's where we get to where we are here today. But one of the things I wanted to point out is that the commission staff and the ALJ both are misinterpreting the commission's own rules. If you go through the OAR's administrative rules here, there's clear distinctions between applicant and licensee. And it says that a licensee must have the metric certificate in order to exercise the privileges of a license. And Mr. Shirley, never exercised the privileges. He never got to that point. And that is a clear distinction that the ALJ just glossed over, because the ALJ, I think, just was kind of, to be honest, didn't like Mr. Shirley. Didn't like Mr. Shirley was a typical Southern Oregon resident, and he had dyslexia, and she just thought that, hey, you're not right here. And so she conflated applicant
Excuse
with.
me. Are you implying that the administrative law judge was prejudiced, or is prejudiced culturally or economically?
I think more economically, Your Honor,
So the
and
answer-
also on I'm sorry, Your Honor, Chair, and also on an intellectual level.
So,
Um,
our law judge is prejudiced.
I think so, because I'll be fair, I'm gonna tell you right here, if, in the future, if I'm ever at a case and assigned with her, I'm gonna affidavit her.
Okay.
So,
Thank you.
so, on that.
I have
So-
a lot of friends in Southern Oregon, so I don't, is it, what kind of people are they again?
I mean, these are people that sort of like what you see written in stories, back to the land people that that moved there in the late '60s, 1970s, and that there's a cultural divide between folks that live in Grants Pass and Medford, and then people live out in the countryside.
Okay.
So,
Please continue.
so all right. So, and again, there's a difference here. In order to submit your application, you don't have to take the metric test. You don't have to take the worker permit. It's clear in the rules here. I mean, I think that's what the commission wants, and it kind of does make sense to have them take the test and submit the test results as part of the application, but that's not what the rules say. It's pretty clear in my reading of the rules. It does not say that. I think the commission needs to go back and amend the rules if that's what they want, especially if that's what the workers. That's what Ms. Naveen seemed to believe.
Could you seem to be very, very versed on those who've already gotten licensed. Could you talk a little bit about what the applicant's requirements and responsibilities are?
Well, the applicants' responsibilities are to fill out the forms that the OLCC says you need to fill out. They put on there everything from the name of their business, who owns what their business names are, their spouses, if they have spouses, if they're a producer, how they intend to grow, where they're going to grow at, the plot plan, camera, security system. Those are all the documentation that Mr. Shirley, submitted.
And is there anything on those applications about truthfulness as an applicant?
I believe at the very last form, when they say that, okay, everything is about to be closed, that's when you say everything is truthful. But Mr. Shirley, application perhaps never got to that point. It never got to that point. Ms. Naveen started to review it and said, hey, okay, you need some of these forms need to be updated since you started the process so long ago. And by the way, the first thing was, well, look, your name seems to be spelled wrong. And he said, well, that wasn't me. I didn't submit those. And that's when basically the process stopped. Right at that point, the commission staff at that point just basically called a halt and said, okay, we're not going to do anything until you take these tests.
Okay.
And I don't think that's not the rule. I mean, maybe that's what the rule, again, that's what the rule should be, but that's not what it is.
Thank you.
So, again, the definition is a licensee under OAR 845-025-1015 sub 38 definition. Licensee means any person who holds a license, and you can't hold a license if you're simply an applicant. There's a difference. So, again, I know I'm saying it over and over, but that is really key here. And the rules, they don't use the terms interchangeably. The rules are pretty clear between a licensed applicant, or a registrant. So, and then Mr. Shirley, he admitted that, yeah, one lie, and he admitted that as soon as Ms. Naveen said, hey, did you take this test at your farm? And he said, well, no, I didn't take it there. That was, there. And then but again, that's the one thing. And he had offered to take it in front of Ms. Naveen and then in front of I don't know his title, so I apologize, and I can't remember his name off the top of my head. And Ms. Naveen said, go talk to this gentleman here in Medford. He went in, met with him, and he offered to take the test in front of that person as well, saying, look, I'll prove to you that it's actually me taking it. Give me a chance to sit down and take the test in front of, he said that to Ms. Naveen, and he said it to this other OLCC worker. And that was denied on that. And so, and then also the administrative law judge, I think, pretty clearly, basically just never even addressed the Vaughn case, which says that, hey, if you hire somebody as your consultant, that doesn't mean you're authorizing them to break the law on your behalf. I mean, that should be pretty clear. And she never addressed that issue. Mr. Shirley never authorized Mr. Nichols to do something illegal or wrong. He never authorized him to do that. It was only after that act had been done and he was scared, he acquiesced to it. And then when he's confronted about it, he said, yeah, Mr. Nichols submitted it. That was wrong, and can I take the test in front of you? I'll sit down right in front of it. Give me a computer. He said that to 2 different OLCC employees. And that, to me, that shows that his good faith, he wanted to show that he could do this. He could be a willing partner with the OLCC, and which is what he wanted to do. And then the materiality, this didn't stop the OLCC from investigating him any further. There was like, oh no, because you submitted a false test, we don't know how to investigate your finances, we don't know how to investigate your security system, we don't know how to investigate your producer plan, your business. There was none of that. There was just one little teeny part of it, which was, it didn't impede the commission's investigation one iota. The commission chose to bring in their own IT investigator and all that, but it didn't impede anything at all. So it's kind of their, I don't know, that's something that shouldn't have been there. And again, the false statement is not a basis to refuse a license. The false statement would have been if you tried to exercise the privileges of the licenses, but there were no OLCC product or plans on his property. There never was. And so, and until he came out and get inspected, normally it's like, all right, he was expecting to come out and get inspected, and then they said, okay, now pay, just like they usually say, all right, you can't exercise your license until you pay your fee. You paid the application fee, but now you need to pay the rest of it. And that's the time there would have been to say, oh yeah, and by the way, make sure, we're not going to give you this license until you pass the test. That would have been the time to do it. And again, the good cause here, Mr. Shirley testified that paperwork can overwhelm him. He testified to that fact. And again, he acquiesced to Mr. Nichols, an OLCC licensed producer who already had his license, and said, hey, if you don't back me up on this, you're never going to get a license. And he was scared on that part, and he admitted later that was wrong. But again, a simple mistake by trusting somebody you hire as a professional, especially somebody who already has a license in an area where you want to get a license. I mean, if you can't trust somebody like that, then who can you trust? So, again, the Clement case, which talks about the good cause factors, the first one, limited English proficiency, no, on that. And then passage of time since the false statement to the hearing. I think there was a significant amount of time that passed, not not huge. And the false statement was never repeated on that. As soon as he was confronted about that, the first time around, it was not a false statement. Even the ALJ said that. It was just, again, the misspelling. And because he never submitted it, it's like not a false statement. The ALJ was pretty clear about that. And then the commission staff said there was 2 false statements because of the 2 tests that were submitted in his name the second time around. And at first he said, yeah, those were taken on my farm when they weren't. But that was one incident. Maybe it was 2 statements, but it was one incident, one interview with the OLCC staff worker. And then whether the applicant disclosed the information, he did. Not at first, but soon as she said, well, wait a minute, we don't believe you. He said, yeah, I was told by Mr. Nichols I had to say this. And whether the applicant received a prior warning about the need for truthfulness. He was told he needed to take a test himself after that first time around when Mr. Nichols submitted, and he said, okay. And that's when he went back to Mr. Nichols and said, hey, Ms. Naveen told me I have to take this test myself. And Mr. Nichols said, too late, I've already submitted something on your behalf. And that's when he froze. And, you know, he shouldn't have, obviously, but he froze there and acquiesced to it. And so, again, I think there's good cause to overcome the false statement. And Mr. Shirley, again, you know, he wants to participate in the legal marketplace. That's why he went through all this, and that's why he continues onward. And that's why, you know, he wanted to go forward with this that's why he requested a hearing. And so I asked the commissioners to overturn the ALJ's proposed order and accept our proposed exceptions. And any questions, I'll take them.
Questions? No questions?
Sure.
Commissioner Harper.
I enjoy the opportunity to work with applicants in regards to this license. Southern Oregon has a fine reputation for producing some good cannabis and producing some good people. You mentioned in your statement at one time, who can you trust? Well, my question is, can this applicant trust the state of Oregon in regards to their enforcement and the reasons why we have certain questions on the application?
Well, yes, and again, the application is separate from the metric test.
Right.
I mean, he answered all, there was no accusations here that he, you know, put down a false security system, that he tried to hide the true ownership of his business. Nothing like that at all.
So we start here with an application process, and from there we can determine if we need to go further. You'd mentioned that Mr. Shirley did understand his name is next to applicant, right? So he's the applicant. Explain to me again why you felt that since he's the applicant, he was not required to do the 2 things that this application required him to do? Again,
It's not what the application required. It is what Ms. Naveen said you have to do, and that's not what the rules say. And if I could,
a question before while you look.
Yeah.
So when Ms. Naveen said you need to take these 2 things, at that point, do you feel that your client should have said, red light, I don't need to do it? Or do you feel that he said, okay, and I'm going to complete these 2 requests? And then when he went to complete the 2 requests, they were sort of mistruths. So what you're contending is he should have stopped the process right then and came to us and asked, well, since I'm the applicant, I don't need to have this. When I go further and get this done, I will hire somebody to
no,
do that
no,
role?
that's not what I'm saying. When Ms. Naveen said, hey, you know, you have to
You're
take these
required.
tests, and he said, fine, he went back to his consultant.
And his consultant said,
And he asked the consultant, you know, and the consultant submitted false tests.
right, the consultant said, hey,
Without-
don't worry, I'll take care of it for you.
No, he didn't even say that. You know, he went back and
Well,
said,
how did
hey.
he have his ID to get online to do the test? I mean, this is all electronic. So he gave his friend his his
Not a friend,
password.
it was a consultant, a
So he
paid
gave his
consultant.
friend his password, and he gave him his entry, and he went in and used his name, misspelled it instead of Shirley, he put Shirley. And you're contending that if he would have said stop, then this consultant wouldn't have took the test and lied for him, and then he wouldn't have been in a place where he literally, I mean, I don't know if he was under any type of oath or anything like that to tell the truth at the time, but if it was over the phone, you know, hell, he could have blamed it on the medicine. You're saying that he did not know when they asked him if who took the test, he said, oh, no, I didn't know. But then you're saying that when he said that, that's when our enforcement officer said, well, somebody took the test, and he failed to come clean. Is that what you're saying? That's when he lied, and you feel that since he lied at that point, we should continue the process because, you know, one good lie is all right.
No, I apologize. I'm trying to follow your question here, Commissioner. And so again, is that since as you folks know, the forms are all electronic, and so that's the consultant had the password and a login name to upload the new forms that the OLCC said on that. And at some point, without Mr. Shirley's knowledge of even occurring or even asked for it to be occurring, Mr. Nichols submitted these false tests into the OLCC system. He had no idea of it until Ms. Naveen said, hey, why were these tests have, obviously your name misspelled on it? You spell your name some other way. And he's like, this is the first I've seen of this, and that's what he told Ms. Naveen. And that's when Ms. Naveen said, you have to take your test yourself. And he said, okay. And so he went back then to the consultant that he hired, an OLCC licensed producer, and said, hey, I need to take these tests myself. And that's when the person said, oh, I already resubmitted them.
Question.
Yes.
Are you asking us to believe or take in consideration that simply because someone has an OLCC license, they somehow represent the OLCC?
No, I'm just saying that is to, that's in Mr. Shirley's mindset. It's like, okay, this person's already been through the process, he must know what he's doing.
Are you asking us, the commission, to believe that someone who has a license is representing us and therefore is giving correct or incorrect information?
No, as I just said, I'm not that. I'm just saying it's what in Mr. Shirley's mind.
Right.
So, and that's why I've said that.
Other questions? Commissioner Kern?
Chair, I just find how if he learned that his name was spelled wrong, he must have communicated that to Mr. Nichols for him to go in and correct it.
I think at some point he must have. I don't remember I don't have the facts right now in front of me of that timeline, but yes, that he came back. But he saw when he went in to meet Miss Naveen, it was certainly because he went into her office to meet with her, and that's when she said, "Hey, you have to take the test yourself." And he said, "Okay," because she confronted him and said, "Is this why is your name spelled differently?" He said, "That wasn't me. I didn't." Yeah.
Excuse me, Paul. Chair Raval and Commissioner Kern, in fact, the evidence showed that our licensed investigator contacted Mr. Nichols as well about the misspelling of the name, and that's how he learned that it was misspelled.
Oh, so that's right. That's how. And again, then Mr. Nichols immediately tried to
correct that.
Correct it before Mr. Shirley ever got to him and said, "Hey, I need to take this myself." And that again.
And so, I want to be clear, Chair, that he is capable of taking the test. Mr. Shirley did say, "I'll sit down and take the test right now."
Correct.
Thereby, we would understand that he is capable of taking the test.
Correct. Yep. I mean, I don't know what his time frame would be, but as Mr. Shine said, that there is no time frame for the test. So, but again, he offered to take it at least 2 different times in front of 2 different OLCC employees on that. And so, and again, and the reason, again, that that good cause comes into play here is because of the rules that make a distinction between an applicant and a licensee. And so there was never, even if this hadn't been caught by the OLCC workers, Mr. Nichols submitting this, there was never, at that point, no danger of Mr. Shirley entering stuff in, doing stuff because he didn't have the ability to touch OLCC marijuana products at that point as a producer. He couldn't have any plants on his property. There was nothing, and that wasn't until he was, if and when he got licensed, in order to exercise the privileges of the license, that's when he needed to have a metric certificate and a worker permit.
Chair.
Commissioner Floyd.
Did Ms. Naveen, have we ever spoke to Mr. Nichols to confirm if in fact he took the second test without Mr. Shirley's authorization?
I'm not sure if I follow your question.
Did Ms. Naveen ever speak to Mr. Nichols, or was he ever subpoenaed to the hearing to confirm if in fact he took that second test without authorization, without Mr. Shirley's authorization?
It wasn't subpoenaed by either side, Commissioner,
So we do not know if in fact Mr. Nichols did take that test without authorization.
Only Mr. Shirley's testimony and also what he had told Ms. Naveen when he was confronted that Mr. Nichols had done it, and then the OLCC IT workers, they traced it to a computer that was located in the same city as Mr. Nichols, not in the same area where Mr. Shirley lives.
Okay.
Chair Rabal, if I could respond to a couple points, I'll pick up with Commissioner Floyd's question. In these hearings, the burden of proof is by a preponderance of the evidence, meaning more likely than not. And the administrative law judge found it was more likely than not that Mr. Nichols took the second test based on a lot of factors. There was the testimony of Mr. Shirley that he didn't take it. There was the fact that it was attributed to, the second set of tests were attributed to his email address, meaning Nichols' email address. There was the fact that the metric test was attributed to Mr. Nichols' IP address. And there was the fact that aside from Mr. Shirley and Mr. Nichols, there was no evidence that anybody else had any interest in submitting these test certificates. And there was the fact that in evidence that Mr. Nichols submitted both the first set and the second set of test certificates to the commission. So the judge did not find that it was necessary to have Mr. Nichols' specific and direct testimony on this point to find by a preponderance of the evidence that Mr. Shirley hadn't taken the test, which was really the key important point, and also that it had been submitted most likely by his consultant. As for the fact of without authorization, Mr. Shirley said that he didn't authorize Mr. Nichols to do that. That was one of his defenses. Now, I'd like to go back briefly to an important point here, because it seems that Mr. Loney is making his entire legal argument on the difference between licensee and applicant, but the ALJ, the judge, did address this argument and rejected it based on the actual language of our rule instead of a paraphrase of the rule, which was given by Mr. Loney. He paraphrased it to say that licensee needs to have metric certification before they exercise license privileges, but that's not what the rule says. So the rule says, and this is a quote from the decision before you, the proposed order, the plain language of the rule states, quote, a licensee must have at least one license holder who is a CTS administrator, close quote. And she put an emphasis on is. Is defined as that which is, and that which is factual, empirical, actually the case. Thus, a licensee must have at least one license holder who actually is a CTS administrator when licensed, i.e. already obtained the metric certification. And then the judge further said, the commission interprets this rule to mean that at least one licensee must have metric training certification as a condition of licensing. The commission's interpretation is reasonable, given that one of the license holders must actually be a CTS administrator when licensed, and that, and I'm going to paraphrase rather than read it all, and that we expect them to start their seed to sale tracking right away. We don't want them to spend a few weeks or months trying to get somebody certified after they've been licensed while they've got marijuana floating around and they don't have anyone qualified to enter it into metric. That would not make any sense, and that would destroy the reason of the rule. So clearly, this is a requirement of licensing. Furthermore, contrary to the argument of Mr. Loney, the judge found, and it's proper under OAR 845.025.1036B, which provides that the commission can require not only filling out the application, but submission of such documents as it designates as a condition of licensing, that licensed investigator Naveen had the authority to require submission of a metric test and a worker permit test when she knew he was the sole member of this LLC, so he's the one who needed metric training, and she also knew from talking to him that he was a hands-on owner, not one of those distant investors who then hires people to do the actual work. He was a hands-on grower, and he would be handling marijuana from day one. Doesn't matter whether marijuana is there or not. As soon as we issue a license, he has the right to have marijuana items there, and he has to be ready. He has to have his metric certification, and he has to have his worker permit if he's the one going to be handling it. So those were proper conditions of licensing, and that argument really doesn't hold weight. I want to mention just a couple other things. The business of offering to take the test in front of, in fact, the evidence is not so great that there was no evidence that he offered to take the test in front of, it was regional manager Hunter, but there was evidence that he offered to take the test in front of Investigator Naveen. Now, remember, Investigator Naveen already gave him a second chance, and then this is what came of it. This would have been the third chance. Plus, that's not how the test is done. Nobody takes the test in front of a licensed investigator. It's a test that's done online. So she didn't, there's no denial. She simply said that's not how it's done. But also, she was of the view, and we think it's proper, that, you know, it's too late. You already got a second chance, and you lied to us, and you lied to me, and so we move on. This idea that applicant disclosed that he hadn't taken the test and that he lied about it on March 8th, he disclosed it at the hearing under cross-examination. He didn't disclose it prior to that. So that's not, you know, there's no credit for that. I want to conclude by stating that the law governing recreational use of marijuana includes among its purposes protecting public health and safety by prioritizing the state's limited law enforcement resources and preventing diversion of marijuana out of the regulated system. The integrity of the state's marijuana regulatory system relies on substantial self-reporting via the seed-to-sale cannabis tracking system. This applicant's proven record of false statements to the Commission demonstrates untrustworthiness and a willingness to disregard rules, and is therefore inconsistent with an ability to maintain the kind of trust that we need to carry out his duties as a licensee.
If I may say one thing, Commissioners.
I'm going to say no right now.
Okay, thank you.
You win, you win, you win. That's how it goes. So now I get to say, the commission will now go into chambers for deliberation on contested cases pursuant to ORS 192.6901. And once we've completed our deliberations, we will, once ready? We're back in session.
Chair?
I believe we have a motion.
In the matter of the application for a marijuana producer licensed by Earth People's Garden LLC, I move to adopt the proposed order and to issue a final order denying the application.
Thank you, Commissioner Floyd. Laura, will you take the roll?
Commissioner Kern,
Yes.
Commissioner Floyd,
Yes.
Commissioner Harper,
Yes.
Commissioner Melides,
Yes.
Acting Chair Reval.
Yes. At this time, I think the commissioners would like to make some comments about who we are and what we're doing and why we're here in this particular situation. And anyone who wants to? Commissioner Harper?
Chair, I just feel terrible for this business, Earth People's Garden, because he's done such incredible work prior to this time. And one misstatement or misstep or idea can cancel out an opportunity to support the state in all that we do. I would hope that through this action, people see that we're adhering to the idea of enforcement here at the Oregon Liquor Control, and we take this job and this role very serious. It's you know, one misstatement or misstep can take a person out of a livelihood, but I'm hopeful that in this case that my family down in Cave Junction see that we did the right thing, and hopefully in the future this will not happen in the future. Thank you, Chair.
Anyone else?
Chair. I second that. I think it's a tough one. I mean, we always try to look at these things and be as thoughtful and deliberate as we can, but it's tricky when we are spread so thin with the resources that we have, and it is really, really incumbent on the licensee or the applicant or whatever it is that they're good partners, that they have to really be able to man their own ship and kind of take responsibility for what goes on in their own shop. And that's, I think that you hate to preclude anybody from their chosen trade, but I think that after a period of time, maybe you look at it, but there's really got to be some soul searching and some thought given to the responsibility of being both an applicant and a licensee, and I think that's hopefully what'll take place.
Thank you, Commissioner Melides. Commissioner Kern?
Chair Reval, I do want to say that we read the materials. We do take this matter very seriously when we're denying somebody possibly their livelihood, a job, employment, and so it is something that we take very seriously. I don't think that there was any missteps on his representation. I think he was fully represented in a way that tried to take every aspect of what could possibly be a good argument to move forward in this case. Unfortunately, you know, some of the problems here is if we had not sussed this out, if he had been able to go forward, there probably would have been problems. And so I worry if we hadn't figured this out and then we have somebody who hasn't had the training, somebody who hasn't done the research and isn't up to speed on what needs to take part, what bad things could happen in the system. It is something that requires that training, that specialized knowledge. And so I did find this to be a material issue that we can't have applicants doing this and seeing if they can get away with it, and whether it was seeing if he could get away with it. But again, the problem is that particular misstep, even though it was maybe one small misstep in a long length of history, there was something that could have put him into the industry, licensing, selling marijuana products to people without the proper training. And that's a concern for public safety. We are up here to support business and encourage business, but we're also up here to protect the safety and community livability, which is the other part of our mission statement. So that weighed heavily in our decision. Thank you.
You know, as a licensee myself, not on the marijuana side, but on the alcohol side, and have been a long lineage of alcohol liquor licensees, it is very incumbent upon applicants to be truthful, be transparent, be honest. And, you know, unfortunately, this is unfortunate situation, and I do take this very, very seriously. Read through all the materials, and you know, unfortunately, had to come to this decision. But hopefully, in the future, this is, you know, it's a teachable moment for him to later. It's an unfortunate situation, but you know, hopefully down the road he can reconvene and apply again down the road.
This is my 5th year in this role, and this is also like the 5th year that we've been involved with this industry. I probably take this role more seriously than the other commissioners because when I was 21, I was a police officer. I read all the material. We're at a point where after 5 years, people are entering this new industry, and I don't believe your client after reading the material. I don't accept the argument that as an applicant, you are not supposed to be truthful. I am a supporter of the new law and what it can do for this state, but I remember dangerous nights and my family being afraid. If those who are in this industry think that we're going to allow it to go back and allow people in it who can't be truthful, you're mistaken. Because that's not who we are as a state. That's not who we are going to be as an industry. And when the rest of the country finally gets it and take our lead on cannabis, I want to make doggone sure that we are still the leader in this field and not doing Westworld, which is where we seem to be heading on occasions. So please follow the rules. Please be truthful or get another job. Thank you. Compliance?
Good morning, Chair Revolt and Commissioners. My name is Tom Mott from Administrative Policy and Process. I'm here with stipulated settlement agreements for your approval. The first 3 are liquor law violation cases, and I'm happy to answer questions you might have about them.
Any questions? Commissioner Kern?
No questions for me.
Okay. Could we have a
Sure.
motion?
Chair, I move to ratify the 3 stipulated settlement agreements as proposed by staff.
Laura, would you call the roll?
Commissioner Kern,
Yes.
Commissioner Floyd,
Yes.
Commissioner Harper,
Yes.
Commissioner Melides,
Yes.
Acting Chair Reval.
Yes.
And on the next tab are 4 marijuana violation settlements.
Questions?
Yes.
Commissioner Melides?
The self-made, I mean, and I guess it's more of just a clarification, why is there 3 of them? Is it, I mean, can you, or I guess, can you just kind of explain the self-made one a little bit?
Sure, Commissioner Melides. There are 3 separate licenses
Yeah.
related to this particular licensee, the 3 separate grows, and based upon the first one is actually the one marked number 3. those violations were discovered as a result of a harvest inspection on October 5th. And based on discussions with the licensee and licensee actually coming forward with information after that point, found that there were similar violations at the other premises.
Okay, so it was one of them that prompted the investigation into the other two.
Correct.
Chair.
Commissioner Harper.
And is it, so out of the three, is it the total payout is in addition to each individual case, each individual price?
Listed in each settlement is the penalty for that particular license. Like total, it's over about $15,000 for all three. Or I think about 90-some days of license suspension.
Yeah.
Other questions? Can we have a motion, please?
Chair,
Commissioner Harper.
I move to ratify the 4 stipulated settlement agreements as proposed by staff.
Floor.
Commissioner Kern,
Yes.
Commissioner Floyd,
Yes.
Commissioner Harper,
Yes.
Commissioner Melinas,
Yes.
Acting Chair Reval.
Yes. Thank you, Michael.
Thank you.
I think we're looking at purchasing.
Nikki.
Yeah.
Nikki?
Drop
Dropping
paper.
paper. You lost some paper.
Chris put me to work.
Hi.
Hi, good morning, Chair Revar, Commissioners. For the record, I am Nikki Leslie, Purchasing Coordinator for the Purchasing Division. I am here today before the Commission to present a listing of activity for the month of December, January, and February. Under tab 1, you'll find a detailed list of activity. Staff recommend Commissioners confirm the 62 items on the list. I'll be glad to answer any questions.
So, Nikki, how are we doing?
We're making money. We're doing good.
I like that.
Yeah.
Questions for Nikki?
Good.
I just, is this new manufacturer, is a swallowtail produced in Oregon?
That's Oregon.
In Oregon?
Yes, all the, you see on the column on the sides, where you see Oregon product, if you see a yes or no, those are all Oregon product that we listed during the 3-month period.
Wow. Wow.
Last.
Yes. Congratulations, industry.
May I have a motion, please?
Chair, I move to confirm the 62 items for December, January, and February.
Laura?
Commissioner Kern,
Yes.
Commissioner Floyd,
Yes.
Commissioner Harper,
Yes.
Commissioner Melinas,
Yes.
Acting Chair Reval.
Yes. Thank you.
Thank you.
So, you'll look at the agenda, and as you may have noticed that our director is not here, and Renee is not here because they're in Salem arguing our case. So, we have a very capable stand-in. Will?
Mr. Chairman, Commissioners, good morning. For the record, Will Higglin, Deputy Director. As you mentioned, Director Martin and Renee are down in Salem as we speak, testifying on some crucial bills, so they couldn't be here today. I know Renee sends out the comprehensive overview of the bills, and we all get that, so I'm not going to go through all that. I'm assuming that you have that information, because nothing significantly has changed at this point. I did want to let you know that, and Commissioner Revolver knows, we had our budget hearing last week for 3 days. Director Marks and CFO Bill Schuette took the lead on that, along with Commissioner Revolve, kicked us off. And frankly, it's early in the process, but it went very well. So we got our 3-day budget in front of the Subways and Means. The presentations went well. There were a lot of questions, and that's just the start of our overall budget process. So we feel pretty good about that. So that's kind of the legislative things, but I just thought I'd take this opportunity to mention a couple other things. I think you know this, we have agent training coming up in April. I believe it's April 23rd and 24th. You'll all be invited to that. The other thing around that we didn't present today, but I just wanted to notify you, we didn't really need to, but we're getting ready for our next public drawing. We're going to launch it at the agent training to try to get even more support through the training and the distribution network. So you'll get that information, and the products that we're going to offer up in the next public drawing has been very, very successful. We just hope to keep growing that, getting more people interested, and keep doing outreach to our agents. So we're looking forward to the next public drawing. Like I said, I think we're going to launch the process at the agent training.
still can't do that.
You still cannot do that. Well, you can, but
Well, get it. Thank you, Will. So we are going to have some compliance training, I understand.
Yes.
Please, and we have a slideshow, I think. Yeah. Oh, it's called PowerPoint in today's world, forgive me.
It is.
Thinking.
Chair Reval, Commissioners, for the record, my name is Shannon Hoffeditz, and I'm the Director of Compliance, and I'm going to provide an overview of the compliance program within the Public Safety Division today. We have inspectors stationed throughout the state in 5 regional offices and 7 satellite offices. We currently have our liquor inspectors are in all of the offices, and our marijuana inspectors are currently in the regional offices, the 5 main regional offices. All of our regulatory specialists, which I'll refer to as inspectors during this presentation, are sworn peace officers. They're required to be DPSST certified, which stands for the Department of Public Safety Standards and Training, certified within 18 months of hire, and maintain their certification while they are employed as inspectors. They're required by statute to attend a 4-week academy and maintain 84 hours of qualified training every 3 years. The compliance program has a total of 77 full-time inspectors, 38 in alcohol, 23 in recreational marijuana, and 16 in medical marijuana. So if you look at pre-marijuana, we now have double the inspectors that we had before we took on marijuana. We haven't acquired any new alcohol inspectors since 2002, and the number of liquor licenses continues to increase. When we implemented recreational marijuana, we anticipated about 1,000 marijuana licenses and planned the staff accordingly. As it turns out, we've issued more than double the amount of licenses, with just as many in the licensing queue waiting to be licensed. With the number of marijuana and alcohol licenses continuing to increase, we simply need more staff. So in the 2019-2021 budget, we're asking for 4 more alcohol inspectors and 8 more recreational marijuana inspectors. So our fingers are crossed. As I previously mentioned, all inspectors are sworn peace officers with limited authority. In the alcohol program, inspector authority is limited to violations of the Liquor Control Act. Inspectors may take compliance action against a liquor license premises and at times may criminally cite for any alcohol-related crime. Examples are minor in possession of alcohol, misrepresentation of age, or furnishing liquor to a minor, to name a few. In the marijuana program, our authority is limited to violations of the Adult and Medical Use of Cannabis Act. Administrative actions are limited to the OLCC licensed businesses or the registered grow sites. If there is any activity outside of the licensed premises that's unlawful, we forward those to our law enforcement partners. The inspector role with all licensed businesses is to help businesses be successful while taking the appropriate compliance action to ensure the safety of the public, patrons, and employees surrounding that licensed business. The medical program is operated through an interagency agreement with the Oregon Health Authority. OLCC inspectors follow the OHA protocols on inspections and reporting, and all of those reports I'll talk about a little bit later are forwarded to the OHA for processing. We do not do those through our Administrative Policy and Process Division here. The inspectors are responsible for 4 areas of responsibility, which are following up on complaints, conducting inspections, providing education, and processing change requests, and I'm going to go into more detail on those. The complaints we receive regarding licensees are assigned to inspectors to conduct follow-up. We receive compliance concerns a number of different ways. One of the ways is through citizen complaints. Citizens may have a friend that got too intoxicated at a business and want our agency to follow up on over-service issues, to complaints regarding minors at marijuana licensed retail shops. And I mean, that's just very generic, but if you can think of a complaint with a licensed business surrounding alcohol or marijuana, we've probably heard it by now. We've also received complaints from police agencies. Alcohol-related DUI reports are forwarded to our office for follow-up. We also receive alcohol-related police reports that contain incidents of disorderly and unlawful activities that we'll follow up with the businesses as well. These reports are assigned to inspectors, and an investigation is conducted to determine if the licensees or their employees have violated any rules. Inspectors will also discover issues at businesses as well, whether it's during an inspection of an alcohol or marijuana-related business or from conducting a walkthrough. Inspectors will follow up accordingly, taking the appropriate compliance action on the issues that they discover. And lastly, the industry. Businesses that are following the rules will often let us know when they discover other businesses that are not following the rules. As these come in, whether through the call center, through the regional offices, or assigned to the inspector will conduct investigation. A lot of what the inspectors do is complaint-driven, so the proactive inspections are very important. It's very important work that we do. It's important to get the businesses prior to the complaints coming in. With alcohol, we conduct first calls, premises inspections, and minor decoy operations. First calls are inspections that are completed within the first 60 days of a business being licensed. Premises inspections are conducted once a year at retail and on-premises locations, and with minor decoy operations, where we use minors between the ages of 18 and 20 with their real ID to try to purchase alcohol. There are more inspection components with recreational marijuana than there are with alcohol. Just with it being so new, we need to get eyes on the businesses as often as possible. We conduct pre-license inspections, which are prior to a business being licensed. The inspector will get notification from the license investigator and confirm the business is set up as they are proposed. The inspector will conduct the inspection, ensure the business is set up correctly, and forward the information back to the license investigator. Sometimes the business is not always set up correctly, so we'll provide them a second chance to get into compliance and work with the license investigator and the applicants. We also conduct proactive inspections on businesses. These are inspections that are conducted after a business has been licensed. We haven't necessarily received any complaints about a business or made any recent visits to the business, yet it's important for inspectors to pay licensees a visit to ensure that they are in compliance. Harvest inspections. In 2018, we passed a rule that required outdoor producers to notify the commission through their metric account when they were going to be harvesting. This prompted inspections to outdoor producers to ensure that they were harvesting within the rules. For the months of August to November 2018, inspectors visited roughly 60% of our outdoor producers and conducted these inspections. When there are change requests at businesses, we like to ensure the business is operating as they were originally licensed, and conduct follow-up inspections to ensure the change is within the rules and the guidelines. And we also conduct minor decoy operations at our marijuana retail shops, where we use minors between the ages of 18 and 20 with their real ID to ensure that the retail shops are not selling to minors. And with medical marijuana, the inspectors conduct site visits from the metric information or from the complaints that they receive. Since the program follows the OHA guidelines, the inspectors only follow up on metric and basic complaint issues. And these are a list of our most common complaints or violations that we receive with alcohol, service permit violations, visibly intoxicated people, permitting unlawful activity, unauthorized interest, operating other than license permits, just to name a few. Recreational marijuana, you can see them in front of you, but what we are primarily seeing are worker permit violations, metric violations, camera violations, and not operating as a license permits. And then with medical marijuana, it's primarily metric violations, since that's what we're tasked with doing. A lot of the compliance work we do, we rely on our community partners. Inspectors regularly attend meetings with law enforcement, local governments, and neighborhood associations. Inspectors provide education on authority and commission action, and will conduct joint investigations such as decoy operations with our partners as well. And this is really This is proactive work that we like to do. If we hear of things happening in a neighborhood before we get a complaint, we'll often go talk with businesses as well when we see these things happening. So networking is very, very important to what we do as well. Compliance investigations. There are 3 levels of compliance actions the inspector can take in both alcohol and recreational marijuana. They are verbal instructions, notice of warning, or notice of violations. With medical marijuana, the inspector will author the report and forward their findings to OHA, as I've discussed. And OHA can also issue verbal instructions, fines, and cancellations. This is the area where the inspector looks at the totality of the circumstances, works with the licensee, and makes what they determine to be the appropriate compliance recommendation, considering the facts that they found during their investigation. I'm going to discuss in more detail the different levels of compliance that the inspectors take. It's the same for both alcohol and recreational marijuana. Verbal instructions is the #1 compliance action that the inspector takes. The elements to support the complaint cannot be proven. The inspectors use this time to educate the licensee and document the instruction provided to the licensee in a report. A notice of warning is where the inspector authors the report. It's serious enough for the licensee to receive written documentation, but does not rise to the level of a violation. The elements of a violation are almost there, but can't be proven. And lastly, there's notice of violation, where the elements of a violation are proven. There's a threat to public safety, or the licensee has received previous instructions or a warning. And then there's also, in severe cases, immediate suspensions, which the business continuing to operate, there's an imminent threat to public safety. We simply have to put a stop to their license immediately, but those are relatively rare. With medical marijuana, because we operate with an interagency agreement with the Oregon Health Authority, inspectors follow the OHA guidelines for conducting investigations. The inspector will gather the facts of the complaint, author the report, and forward the report to OHA, and then OHA has their own administrative policy and process, so all of the cases are adjudicated out of OHA. After the inspector has completed their investigation, warnings and violations are referred to our Administrative Policy and Process Division. The case presenters work with the inspectors on cases while the inspectors continue to work with the licensees with the goal to abate the violation and get the licensees operating within the rules. If the licensee contests the case, the licensee has the right to an administrative hearing, and at the hearing, inspectors testify to the facts surrounding their investigation. Final orders to these hearings come before you to make the final determination. I want to talk about our accomplishments. It's been an exciting 2 years. The recreational marijuana inspectors are fully staffed within the regions. We've hired all but 1 medical inspector. Some of our alcohol inspectors decided to transfer to the new programs, which is exciting for the existing staff. However, now we have some vacancies on the alcohol side to fill, so we're working on those. We worked with our IT division and developed a temporary fix to track all the inspector compliance activity. Prior to 2018, all of our compliance activities were documented on spreadsheets. And honestly, that was a logistical nightmare trying to gather and pull stats. Our statistics going forward will be more consistent now that we have this in place, and we're looking forward to our larger IT plans. And really what our IT put together for us, it's really a Band-Aid until the bigger program comes out. I'm going to talk about numbers with alcohol and marijuana. In alcohol compliance work in 2018, we issued 1 immediate suspension, 20 proposed license cancellations, 340 notice of violations, 15 letter of reprimands, and 87 notice of warnings. Since we implemented Case Manager, we're now able to track the number of verbal instructions, so it's not for 2018, but over the last 6 months, we've issued about 700 verbal instructions to our liquor licensees. In recreational marijuana, in 2018, we issued 3 immediate suspensions, 57 license cancellations, 97 notice of violations, and 37 notice of warnings, and about 780 verbal instructions. We also issue 4 letter of reprimands to licensees whose licenses have expired, but they had pending compliance activity. We started medical marijuana compliance work in September of 2018. The medical program currently has 144 active investigations pending. They've completed 97 investigations that have been referred to the Oregon Health Authority to follow up. And I just want to stress that the 144 active investigations that we have, we're finally up to full staff and getting those folks trained. So we conducted pretty much the 97 investigations half-staffed. TJ Sheehy and the Metric team have set up automated warning letters out of the Metric programs to notify our licensees when there are issues with Metric accounts. So far, we've issued over 11,000 of these letters to our licensees. With all the changes going on within our agency, it's important to keep the inspectors updated, and we've set up our process guides for marijuana inspectors and set up quarterly trainings for both our alcohol and marijuana inspectors, so we can keep everybody up to date and current on the changes that are occurring. And most important, I want to stress the compliance staff, management team, and the inspectors have done a tremendous job working through change and helping formulate the processes. I'm really proud of the work we have been able to accomplish in the compliance program to foster and keep alcohol and marijuana businesses operating safely throughout the state. So thank you very much.
Thank you. Comments?
I have a couple comments.
Commissioner?
I just wanted to thank you, Shannon, and also Paul Rosenow and Carly and Hector. They had the chance on last week to go out with the inspection team on the alcohol side, and it was extremely eye-opening. There was a lot I understood, but a lot that I was made aware of that I had frankly no idea of. I mean, one of the things I was most struck with was, as inspectors, as the OLCC, we're really on the front lines and in businesses where a lot of other crimes go on. And I think we've all kind of understood that, but our inspectors have an extremely difficult and important job, and they're kind of the tip of the spear in a lot of ways to be able to see whatever's going on in the community, whether it be, all kinds of stuff. I'll let you guys talk to the inspectors directly, but there was some really interesting revelations that came out of that and what they deal with and how dangerous the job actually is. I also, I had requested sort of this presentation and just to be a little bit more well-versed, because coming from the industry side, I hadn't had as much experience as Chair Raval has in law enforcement, and being in this position, I will get both sides of it. I'll get, as I'm sure all of you guys do, I'll get complaints from industry about bad actors on that they're, other licensees that are not following the rules. I'll get, if there's a violation, someone will reach out and be like, oh, so it was really important for me to understand the process and to really experience it firsthand. And after kind of seeing it, I have an immense amount of respect for the work that goes into this of the OLCC team, kind of the how it's evolved, and really just what's been thrown at the team with taking on marijuana. And it's been a huge task that I think that the agency doesn't get enough credit for how well they have performed under a tremendous amount of pressure. So I just wanted to kind of put that out there and thank you guys for taking the time. And I think we've got some more ride-alongs scheduled as well. But from what I've seen so far, it's been extremely impressive, and I'm very appreciative of that. Thank you guys.
Thank you.
Thank
And
you,
I would
Commissioner.
invite any of the commissioners, if you would like to schedule a ride-along, please reach out, and we'll take you out and show you what goes on out there.
Anyone else? Commissioner?
I'm extremely excited about hearing these numbers, because I've been a huge proponent of, instead of fees and fines, prefer communication. You mentioned over 11,000 letters to licensees. There are over 700 verbal instructions to our business owners, and that's minus a fee, penalty, or cash to the state.
That is correct.
And I just love that. I think that the reason and the way we can stay in business is by the simple opportunity to know the business and know what's going on. and we're ever evolving. So I really appreciate what we do here at the OLCC. I more importantly like to say thank you to assisting the people out there in traffic safety. That extension of our role in regards to talking to our licensees help people on the road. And we are touched daily by people involved in either drinking and driving or drugging and driving. So that all goes hand in hand with what we're trying to do with the state and keep our numbers low and to help people from just riding a bike, crossing the street, or just getting to and from work. So thank the crew, thank the staff. I'm excited. We got one more opportunity for someone to work. So hear this message, put in an application. And thank you, Shannon. Thank you, team.
Thank you, Commissioner.
Thank you, Shannon.
Thank you.
Thank you.
Anything else for the good of the order?